All right, I think we're going to start. Are you ready?
I think no.
Yeah. So good afternoon to everyone who's here with us in Washington and to everyone who's here with us on the internet. We welcome you to today's discussion of the argument in the consolidated cases of Halo Electronics versus Pulse Electronics and Stryker Corp versus Zimmer Inc. We have a distinguished panel, and their bios are available on the web, so I will just briefly indicate their affiliation, and then we're going to jump into the issues and the discussions. To my immediate right is Don Dunner, a named partner at the Finnegan Henderson, I don't have it in front of me.
You don't need me.
Okay. Law firm, Dunner.
I'm the last dot.
Yeah. A longtime friend of the program and one of the deans of the patent bar. We're delighted that Don could join us. To his immediate right is James Otteson, who's flown in from the Los Angeles office of Arnold and Porter, who wrote an amicus brief on behalf of the petitioner, or in support of the petitioner's position. Petitioner's counsel were not able to join us, and James is going to carry the water on explaining the position on that side of the case. To his immediate right is Michael Feldman of Dangi Turi, is that the right way? Durit Hungary, sorry, who wrote an amicus brief that's the polar opposite of the brief that Jim wrote, so it's great that they're sitting next to each other. To his immediate right is Chris Seaman from the Washington and Lee Law School faculty, who wrote an amicus brief on behalf of a small group of law professors. And to his immediate right is my good colleague, Jonas Anderson, who is not involved in this case, but who will be commenting and also helping us understand the position taken by the United States in their brief, because the United States does not comment on pending cases, but they actually got time at the argument. The issue presented is essentially what is the proper legal standard that district courts should use when awarding enhanced damages for patent infringement. It's in Section 284 of the Patent Act, 35 U.S.C. Section 284. The text of the statute appears to be open-ended and discretionary, but the Federal Circuit has curtailed that discretion by requiring showings of willfulness and recklessness before the award is appropriate. There are many reasons for that, which we'll hear about in a moment, and the court was struggling over what to do with the Federal Circuit's test and the tests proposed by the different parties and amicus. Interestingly, part of what's going on in this case is what's going on in patent litigation. The fact that non-practicing entities are filing numerous claims and sending letters, demand letters, shows up throughout the amicus briefs and shows up in the argument as a concern about how tight or loose this standard ought to be, how much discretion district courts ought to have, what the standard of review ought to be in the Federal Circuit. And so there's a range of issues hooked to a fairly small piece of statutory text. So with that introduction, I'm going to ask Jim to first explain why the petitioners sought certiorari and what it is that they wanted in terms of the change in the law.
All right, thanks, Mike. So very happy to be here. I didn't realize that I was going to be doing the job of all of the petitioners whose counsel didn't show up, but here I am, surrounded by friends who were taking opposite positions for the most part, but not a problem. So the statutory basis for enhancement of damages in patent cases, as Mike said, is 35 U.S.C. Section 284. And what Section 284 says, the relevant part of it says, when the damages are not found by a jury, the court shall assess them. In either event, the court may increase the damages up to 3 times the amount found or assessed. So it is open-ended, as Professor Carroll pointed out. Now, historically, the test for willful infringement, which is often a hook, or has historically almost always been a hook for enhanced damages under Section 284, has been a totality of the circumstances test. So this is a test that goes back decades, up until the Seagate case was decided. This was, I can't remember the exact date, 2007 or 2008, where the Federal Circuit came up with a two-prong test, an objective prong and a subjective prong for determining willful infringement. So essentially the Federal Circuit determined that, first of all, the defendant, in order to be liable for enhanced damages, for example, treble damages, had to basically could not have an objectively reasonable defense. And so that was the first prong. The second prong was that that the defendant also had conducted the case in bad faith. So it's more of a subjective test. But basically, the framework was that the objective test came first. So the defenses had to be objectively baseless. So the way that's been applied now by the Federal Circuit since that time, over the last 8 years or so, is that that is reviewed de novo. So the objective prong is reviewed de novo by the Federal Circuit. In other words, if a patent infringement defendant puts forth a defense, whether it's non-infringement or obviousness, whatever, that it loses on, there could be a jury verdict against it or whatever, but the Federal Circuit, for whatever reason, decides that it's close enough, it was objectively reasonable as a defense, then it can overturn a finding of willfulness and therefore enhance damages. So the thrust of the argument made by the petitioners is that the Supreme Court's decision in the last term in the cases of Octane Fitness and Highmark basically rejected that very same framework that the Federal Circuit had set up for the award of attorney's fees under Section 285 of the Patent Act. So the text of Section 285, I think, is relevant. It says, the court in exceptional cases may award reasonable attorney fees. So again, this is pretty open-ended language. It's very similar to the same language, or it's very similar to the language of Section 284, where the court has discretion to award attorney fees in exceptional cases. And in Octane Fitness, the Supreme Court rejected this, a very similar two-prong approach, where first of all, the litigation had to be objectively baseless, and it had to be conducted in bad faith. And the Supreme Court rejected that in favor of this totality of the circumstances test that had been applied historically in similar situations in patent law and also in other contexts. So if we look at one of the petitioners' cases in particular, and we'll take Stryker as an example. In the Stryker case, Stryker manufactured a product which is a lavage device. Basically, it's a pulsing lavage device which washes out a wound during surgery. And it had some success with it. It applied for patents on it. At least the fact pattern that they recited in their brief, and Don may take exception with this, but he'll get his turn since he represents Zimmer, was that Zimmer saw the success of this product and came out with their own, which was not a direct copy necessarily, but it didn't do very well. So they eventually pulled it from the market and then decided that they wanted to make a lavage pulse device that was almost identical, that was very, very similar to the product that was sold by Stryker and also was patented. However, at oral argument today, Carter Phillips was quick to point out, well, he did point out at some point that that what Zimmer copied was the product, not the patent. But nevertheless, Zimmer continued to manufacture this product even after it became aware of the patents. So there, the case eventually went to trial. There was a jury verdict of willful infringement. Zimmer filed a JMAL motion to get judgment as a matter of law that it was not a willful infringer, in spite of the jury's verdict. And the district court went through quite a lengthy analysis to determine that, in fact, it agreed with the jury's verdict, and there was substantial evidence to support the finding of willful infringement. The district court also went through this two-prong Seagate's objective prong, subjective prong, determined that the defense was not objectively reasonable, or the defenses that Zimmer had at trial were not objectively reasonable, and therefore awarded treble damages. So, fast forward to the Federal Circuit. The Federal Circuit reversed on willfulness by applying this two-prong Seagate test, and basically said that even though Zimmer did not prevail on the defenses at trial, they were nevertheless objectively reasonable. So that's how the case ended up in the Supreme Court. Now, in addition to arguing that Section 284 for enhanced damages is very similar to Section 285 regarding attorney's fees, in its briefing, Stryker also argued, basically it argued, as I said before, that the standard for 284 should be essentially, very similar to the standard for 285, which the Supreme Court set forth last term. In addition, Stryker went through a historical analysis where it looked at how courts had applied the standard for enhancement of damages historically, going way back into the past, even before the enactment of the 1952 Patent Act, and basically argued that it was always based on a totality of the circumstances. It was always left to the discretion of the trial court, so it was reviewed for an abuse of discretion. And so that's basically the argument that Stryker made. So now, since I didn't know until last night I was going to have to explain all of that to you guys, now I'm going to take the opportunity to talk about my case, which I think is an even stronger case than Stryker's. And I'm sure Don, will probably disagree with me, because as it turns out, Don is counsel for the other side in my case too, which is Intervention versus MGA Entertainment. So, very similar situation. I filed an amicus brief on behalf of Intervention, and I also have a writ petition that's pending before the court, which we asked the court to hold pending the determination of whatever they decide to do in Halo and Stryker. So my case, I think, at least to me, it's more interesting technology. It's actually a board game that is essentially a laser strategy game where you have pieces on the board that have mirrors, and you fire a laser and try to deflect the laser around the board to hit the other side's king. And in our client's game, it's an Egyptian-themed game, and so the king is the pharaoh. So you're trying to kill the other side's pharaoh by deflecting these lasers around the board. So this was conceived and created by a professor at Tulane University in New Orleans, and he was a mechanical engineering professor, and two of his students. And they formed a company based on this game called Intervention Toys, which is my client. And they manufactured the game. They were very excited about it. They presented it at a toy fair in New York City Really the company was just the three of them, but they had these games manufactured in China, started selling them, and lo and behold, they go to the toy fair the next year, and buyers tell them, hey, you know, we really like your game, it's really cool, but we can't buy it. And our guys say, well, why not? Well, because somebody else, we've already committed to buy it from somebody else who is selling one just like it. Now, little did our client know, it was MGA. And basically what happened is, as soon as our client started selling their game, MGA bought a couple of copies of it, sent them to their game designers and manufacturers. One of them actually noted when he looked at our client's game that it said on it patent pending. And so one of MGA's game designers said, hey, this says patent pending on it, do you know, and this is in an email, do you know what part of the game is patented? And the response from, this was actually directed to the alleged inventor of MGA's game, Laser Battle. He said in deposition, you know, I don't know whether I ever really responded to that, but we obviously proceeded with our game. So here we have somebody who knew about some patent rights, or some, at least patent pending at that time, and proceeded in the face of that. Now, time goes on, we get our client gets their patent application published. They send it to MGA with a letter saying, hey, you know, we think you infringed this, you should take a look at it. Silence. Absolutely no response. A year later, the patent issues, and our client sends the patent to MGA and says, hey, you know, we really think you infringe our game, or our patent, and you know, we're going to sue you if you don't stop selling. Well, MGA decided they weren't going to stop selling. So this got litigated. So what happened then, I'm going to try to fast forward and cut this down a little bit, but basically there was summary judgment of both infringement and validity that was appealed to the Federal Circuit, and the Federal Circuit affirmed on infringement, remanded on obviousness. So that at that point, it was back in the trial court, and the issues for trial were whether or not the patent, my client's patent, was obvious, and whether the infringement was willful. So we went to trial in New Orleans in November of 2012, and we got a jury verdict of willful infringement, and also that the patent was non-obvious. So they did not prevail on any of their defenses. After quite a bit of briefing and litigation on the issue in the district court about willfulness, because we were asking the district judge to find that there was willfulness under the Seagate test, and Mr. Dunner's client, MGA, was asking the trial court to reject willfulness. She ultimately authored a 63-page order in which she carefully went through the obviousness defense that MGA put forth at trial, and found that they actually failed on every single gram factor. I don't know how patent savvy our audience is, but in order to show obviousness.
Well, we can let's get to the enhanced damages. So, okay, so she rejected that in the order. You went to the Federal Circuit.
We went to the Federal Circuit. The important part is, though, she found that their defense was not objectively reasonable, because they failed not only on what the differences were between the prior art and the patented invention, but they failed on everything else too, all of the gram factors. And so ultimately the Federal Circuit reversed on willfulness, and the Federal Circuit found it's very interesting. The Federal Circuit acknowledged that they didn't have a very good obviousness defense, because they lost on every single gram factor, but nevertheless said that, well, you know, the prior art was close enough to the patent that it was not an objectively baseless defense. And so that's why, we lost at the Federal Circuit. That's why we filed an amicus brief here, because I think it's a very pointed example which shows what is wrong with the two-prong test. I mean, if you can get a jury verdict of willful infringement where the defendant had a defense that failed on every single element, but the Federal Circuit then can basically take that and say, well, we think it was close enough. We're not, we don't have a regime where there could ever be a finding of willfulness in an appropriate case.
Okay, and that's the essence of the petitioner's case. And so,
Yes.
Don, help us understand the respondent's response to that.
I can give a my cousin Vinny response, but I won't.
I like that one.
I don't know how many of you are familiar with my cousin Vinny, but if not, you ought to see it. Classic movie. Well, the 800-pound gorilla in the room in the cases argued today, everybody thought was Octane Fitness and Highmark versus All Care. And it is coincidental that Carter Phillips, who argued today on behalf of both parties, the respondents, as a result of a coin flip. I don't know if you know that. Two cases went up today, and they asked for divided argument. Supreme Court said no, so they tossed a coin. It was Super Bowl 51 or something. And Carter Phillips won the coin toss, so he argued for everybody. He actually had argued Octane Fitness, and I argued on behalf of All Care. We argued on the same day, a year and a half ago. And so it was a reprise of the same kind of arguments, and the petitioners took the position that this was 284, which is the enhanced damages statute, really should follow the law on 285, which was the attorney fee statute, the exceptional case statute that was argued in Octane Fitness and All Care. Interestingly enough, I took notes. If Octane Fitness and Highmark were mentioned today by the justices, they must have whispered, because it was not really a factor. What was a factor today was the issue of trolls, non-practicing entities. We'll talk about that a little later. Justice Breyer went into that in great detail. But the position of the respondents, both respondents followed a parallel path in their briefs. And the position basically was they recognized that, at least superficially, Octane Fitness and Highmark were forces to be reckoned with in this case, because superficially it looked like a reprise of those cases. And so they had to and did distinguish them on the ground that attorney fees under 285, this was one of the grounds, is a compensatory statute, whereas enhanced damages under 284 is a punitive statute. And they too relied, both respondents, on case law going back 150 years, and they reached a conclusion opposite to the conclusion that the petitioners reached. Petitioners argue it's totality of circumstances, as Jim mentioned, and they did argue that to it fairly well. And the respondents argued, one, that all of the case law focused on willfulness, and there's a Supreme Court case which was the subject of briefing by the government, by everybody, called Safeco, which dealt not with patents but with a punitive damage issue. And there's some good quotable quotes in Safeco, which basically says that when you have a punitive damage position and recklessness or willfulness is the test, it equated all these words, willfulness, recklessness, or what, you use an objective test. And there are other cases which suggest that you have, it's conjunctive. You have a objective and a subjective test. So Jim correctly pointed out that the view of the respondents was that, and the view of Seagate is that if you don't satisfy the objective recklessness test, you don't even have to go to the subjective test. But if you do satisfy the objective recklessness test, you also have to satisfy the subjective test. In other words, it's a very high bar. And one of the arguments was, the feeling was that everybody's concerned about non-practicing entities. Everybody's concerned about trolls. And the argument was, and was made today by Carter Phillips, that, and also this paralleled a long speech given by Justice Breyer preceding a question, that there are a lot of small companies out there, and if they get a threatening letter from a non-practicing entity that asks them for $10,000 or $20,000, and the penalty is willful infringement and treble damages, they are going to fold. And as Carter pointed out, and as was pointed out in the respondents' briefs, there is a public interest in permitting potential accused infringers to go to the edge and challenge patents. And if the patents are bad, then they will fold. And if you have a too easy willfulness test, you're going to dissuade them from challenging. You're going to encourage non-practicing entities to continue what they're doing, and that was a critical part of the respondents' position. And that resonated in spades with Justice Breyer. As others who were at the hearing today will tell you, he mentioned that extensively. I mean, he really gave what effectively was the respondent's brief on that issue. But I might mention that he was the only one who expansively and enthusiastically took that position. The others, Chief Justice Roberts, talked about discretion. Hasn't the rule basically been a discretionary rule, and the statute is very broad, and what have you. But the statute doesn't mention willfulness, and almost all of the cases, and everybody agreed, the government agreed, everybody agreed, that willfulness was part of 284, that the case law going back 150 years basically said that. They disagreed on what the impact of that was. So willfulness, so what? Does that mean you have to have an objective and a subjective test? And the basic theme today by some justices, and certainly the government argued, Roman Martinez and Mr. Wall argued for the petitioners. They basically argued you're going to let, if Jim's characterization of the facts is accepted, you're going to let this outrageous infringer, MGA he says, but, I personally thought MGA should have won on the merits. I argued for MGA, and I also thought that Zimmer should have won on the merits, and I argued for Zimmer at the Federal Circuit. So I'm the scoundrel involved in both of these cases. But basically, their argument is, one, a legislative history argument. It's a troll argument. It's an encouragement of accused infringers to go to the edge to challenge what may be bad patents. And interestingly enough, the American Invents Act had added a section, 298, which said that you cannot require to prove willfulness that there was an opinion of counsel. And so there was an amicus brief filed, of all things, by several senators and several congressmen who said that when they considered the American Invents Act, they thought Seagate was the law and should stay the law. That was not mentioned by anybody today, but there was a brief like that. It's kind of an interesting brief. And if Justice Scalia was sitting there, he would have brushed it off with the back of his hand, but he wasn't there, and I don't know how anybody else will treat that. But so there was a public policy argument by the respondents. There was a congressional history argument by the respondents, and all the things I mentioned were basically the view of the respondents. And the big issue was, would eliminating the objective test and going to a totality of circumstances test, would that, first of all, result in not a lack of uniformity? Another point Justice Breyer made, that the whole purpose of the Federal Circuit was to have uniformity, and the best way to get uniformity in this area was to have one court opine on the objective test, reviewed de novo. So, I mean, everybody else can talk about how the justices responded to that, but that basically sets the stage for further discussion.
Right, and if I can just point out for the benefit of the students, this is a really important teaching point, which is, you really can't judge a book by its cover when you do statutory interpretation. The court took into account this long history of judicial practice, whichever version of history you accept. They understood that Congress was enacting law against a background, and that background has to be taken into account. And I think this is such a good teaching case for that proposition, because the language that we heard says nothing about willfulness on its face, and yet everyone agrees that some version of more than negligence is required before we can get to enhanced damages. So Jonas, the United States was offered an opportunity to argue, and essentially it felt like a bargaining session, right? The justices didn't want to stick with the Federal Circuit test, didn't necessarily want to go totality. They're looking for some middle ground, and the United States often plays the honest broker. So what did the U.S. have to say about this?
Yeah, so the U.S. makes two main points in their brief. They argue, one, that Seagate is too high a standard, but not too high. It's just almost right, but not right. And a second one that's about timing. So the first one says subjective intent alone should be the basis for enhanced damages. That's their first point. Their second one is you can't judge whether we've had misconduct anywhere along the trial. You can't come up with some argument that's objectively reasonable in that time. It has to be made at the time of infringement. So what we're doing essentially is saying, would a reasonable person have made this decision knowing what the actual infringer knew here? And the Federal Circuit does something slightly different, which is saying, would the reasonable person have done this knowing everything that we know now? And so the government argues it's the first that should be done, and the Federal Circuit takes the latter position. So those are the two main points of the brief. They don't differ. I couldn't figure out exactly how they differed from the petitioner, and I don't think they do really. The main thing is the government thinks that three types of cases should be applied. This should be applied. When we have good faith, reasonable belief of invalidity, we don't have enhanced damages. That's the first type. The second is reckless conduct at the time of infringement. And then we have egregious misconduct like espionage. Those are the three cases that the government thinks enhanced damages should apply to, and only those three. And the petitioner seems to say there's maybe a fourth type, and the government doesn't want to go that far. But essentially, the government and the petitioner agree on this issue. The two main points are the first two I said. And that's largely the government's position in this case.
That's known as the three-bucket test.
Yeah,
Yeah,
the three buckets.
the three buckets of
Yeah.
cases.
That's how he characterized it.
And there might be four that the petitioner created the buckets.
Right, and just to make sure we're drawing out, I mean, the sticking point that we're going to get to in a minute is that under at least one version of the Federal Circuit's test, if you prove that at the time of infringement, the infringer knew of the patent and intentionally took the acts of infringement knowing of the patent, that alone would not, under the Federal Circuit's test, be a sufficient basis, because if at trial they could put forward a a objectively reasonable defense, that would be enough to get out of it. And so that's why this point of timing is so critical, is it would allow for intentional acts that often seem to be the trigger for enhanced damages not to be sufficient. And that, Justice Sotomayor in particular was very troubled by that.
They had a back and forth talking about, imagine a case in which someone infringes the patent, and then later in trial, their attorneys find some Russian art, and they can point that and to invalidate the patent. It doesn't invalidate the patent, but it's close. And they say, look, we're not objectively unreasonable. If you look at that, that's a good excuse not to believe the patent. But at the time of infringement, they didn't know about those facts. So that's maybe a simplistic way, but it's a way of distinguishing the two types of case the government's talking about.
Yeah. So, Michael, you represent some companies that have an interest in this litigation. What's their interest in? And you said the Federal Circuit doesn't have it right. They're not hard enough on damages.
That's exactly right. So we represented a group of internet companies.
And you might need to grab
Sure.
the mic for the webcast.
Which were Netflix, Roku, Twitter, LinkedIn, Mozilla, and Checkpoint, all of whom are patent owners, but also are keenly aware of what it is to be sued as a patent defendant. And to your point, we said that in fact, the Seagate test is over inclusive in terms of when it asserts willfulness. And the main thrust of the brief is that there is a very problematic gap between the test for willfulness and the standard required for declaratory judgment. And that creates a very real drag on companies that are trying to innovate. So essentially, patent owners, especially trolls, have a tendency to abuse this gap by sending letters that say, you infringe our patent, knowing that under the Seagate standard, and certainly the prior standard, underwater devices, I think it was, all you basically need to do is know about the patent, and a lot of things are triggered. So under Seagate, it's no longer a requirement that you do an investigation, but many courts still look into whether or not you've done an investigation, and certainly most companies who receive a threat letter like that feel required to get an opinion of counsel, which can cost $10,000 to $100,000 depending on how specific the letter is or how complicated the patent is, how many claims there might be. And it's a really easy way for patent owners to sort of manufacture a allegation of willfulness, which is why you see somewhere between 80 and 90% of patent cases allege willfulness, depending on which studies you're looking at, whereas only about 10% of those cases, of patent cases generally, allege that the defendant actually copied the patent. And that gap is really striking. So whenever a patent defendant gets a letter, they go out and get an opinion of counsel, and that in and of itself is pretty expensive. It's not practical to investigate every single letter you get or every single patent that's in the space. There are, I think at this point, something like 2 million patents in force today. 300,000 are added every year. It's just not possible for especially a small company to be investigating and getting opinions of counsel on every patent in their space before they innovate. And this creates a real problem. Companies are forced to choose between whether they're going to carry this risk forward and continue their business, or whether they're going to just entirely stop making the product. The real gap here comes with the Declaratory Judgment Act, or the standard for declaratory judgment, because many threat letters are sufficient to ping the defendant for willfulness. You know about the patent, you're required to do an investigation. If you don't do a hundreds of thousands of dollars investigation, you might be pinged for treble damages if we sue you eventually. On the other hand, the standard threat letter that just says, we own this patent, we think you infringe, sincerely, patent owner, is not enough to invoke declaratory judgment. So there's no way for the defendant, the potential patent defendant, to resolve their risk in any meaningful way, and they're forced to either continue a potentially infringing activity or abandon what could possibly be their greatest product entirely. Our brief also made the point that this sort of really undercuts the purpose of the Patent Act, because one of the stated purposes of the Patent Act is that a patent owner gets a monopoly on a particular kind of technology in exchange for disclosing it to the public. But if disclosing it to the public, if when you disclose it to the public, you can also threaten anyone who knows about or reads that patent with treble damages, you are simultaneously sort of disclosing to the public, but protecting that information with the pointy stick of treble damages, which can be very problematic. And as a result, a lot of companies under the prior standard and under Seagate still today tell their innovators, their scientists, their engineers, not to read patents, not to look at patents, and not to innovate, and not to use that information when they innovate. That is a very real thing that happens in many companies today, and it, I think, is inarguably not what we want from the patent system. We want the patent system to be putting information out there so that it is available and used by other people to advance technology, which is not happening. The over-inclusiveness of the current Seagate test is really, I think, best seen in two particular cases. One is the independent inventor. You can have a company that independently invents some technology that is also patented but doesn't know about the patent at the time. They design, implement, market, produce, and can be selling that product for a long period of time, and then they get a threat letter learning for the first time of the patent. That company, even though there was no bad faith, even though that there is no evidence that that company knew of the patent, can still be held liable for treble damages, for 3 times the amount of whatever the jury finds, simply because later on it turns out that they didn't have a good defense, and so they're forced to carry this risk or abandon the technology entirely. It in a very real way allows certain patent owners to sandbag defendants and not sue for a long time until that company has really committed to a particular technology, and only then come in later and send a threat letter.
But didn't petitioners give away that argument? Didn't they say the notice has to be sufficiently, I have to draw your attention to the claims before I can call you reckless in the way that you just said?
So the petitioner definitely argued that there are different levels of threat letters. Some that, as I mentioned, just say, we own this patent, we think you infringe, goodbye, and some that are real claim charts. In either case, though, even if you get a claim chart, that still doesn't absolve the problem of the independent inventor, who may conceive of, develop, market, commit to a product for years and years, and then receive a very detailed threat letter. I mean, certainly better threat letters are a better situation than a terrible threat letter, but a more detailed threat letter is better than a sort of cursory threat letter. But it still doesn't change the problem of an independent inventor who gets pinged for willfulness, despite the fact that they were certainly not willful when they adopted their technology. Right. The other, I think, most sort of parade of horribles worthy situation is the end user. There are many situations. The Patent Act creates liability for people who manufacture and design technology that infringes patents, import, and various other things, but also imposes liability on companies or persons that use the patented technology. So there's a very real possibility that a company that does not design a product can be using that product and be pinged for willfulness. They can adopt, for instance, some network security device. They buy a box, they put it in their network. This is our email server, or this is our firewall, or this is our whatever it happens to be, and have no idea how it works. Then they get a threat letter from the patent owner saying, that box that you have installed that you know nothing about infringes. And without doing an investigation based on information that user simply does not have, they could still be liable for willful infringement. So our brief at the end of the day proposes a test that takes into account actually a different time period than the government was mentioning. There was a lot of talk today about knowledge at the time of infringement, but at the conclusion of our brief actually suggests that we should be looking to whether or not the patent defendant actually copied or actually knew of the patent at the time they implemented their technology. And that really is, if you're going to talk about willfulness in the colloquial sense, or in the sort of plain language meaning of willfulness, we should be looking at did the patent defendant at the time they adopted their technology know or intentionally or willfully blind to the fact that their technology was patented.
Okay, great. So I want Chris to get in because the case is now submitted, so I want to turn our attention from the case itself to the decision makers who are going to resolve it. So Chris, if you can briefly tell us how the professors are going to try to help the court solve this problem, and then why don't you kick us off on your takeaways from, if you're willing to give us a bet on who's going to win.
No, I don't go that far. But no, thank you, Professor Carroll. So the brief that I co-authored with Professor Jason Rantana at the University of Iowa College of Law, and we submitted a brief, as Professor Carroll mentioned, on behalf of a small group of intellectual property professors. Both Jason and I had written about willful infringement after Seagate, so we decided to join forces on this brief. But as law professors, we were interested in making sure that patent law serves the constitutional purpose of promoting innovation, right? And obviously, as all of you know, how the patent law does that is by granting exclusive rights to an invention, and then serving that, incentivizing through monetary compensation, either being able to bring a product to market and exclude competitors, or to license the technology to others who intend to bring the product to market, right? So patent law serves that very valuable goal, but also overly strong patent rights can actually deter innovation for a lot of the reasons that I think Mr. Feldman cogently mentioned. Can hinder independent inventors, it can shut down startups, as Justice Breyer. And so striking that balance between having sufficient protection for innovation, but not too strong such that it would actually hinder innovation, I think is an important policy. And so that's why I think our brief on behalf of neither side actually sort of gives perhaps half a loaf to both respondents and petitioners. And so what we've argued in our three main points are, first, was that willfulness is the appropriate standard for awarding enhanced damages. We had a fairly lengthy journey through about almost 200 years of enhanced damages in patent law, looking at cases that since the 19th century fairly consistently limited discretion for enhanced damages for willful or wanton or bad faith infringement, and to the extent that some other grounds used to exist, such as attorneys' fees for litigation misconduct, these grounds have been separately addressed in other statutory language like Section 285 of the 1952 Patent Act. But despite this very consistent body of law, Congress had not changed the Patent Act, the remedial provision for increased damages, since 1836. Congress had amended in numerous other ways, for example, adding reasonable royalties is one possibility for damages, prohibiting patentees from obtaining an accounting of infringers' profits, but did not change the language regarding enhanced damages. And so our argument was that Congress, in passing the 1952 Act, continued to carry forth that willfulness standard going forward. And I think in particular Section 298, which Mr. Dunner had mentioned, I think also plays an important role in our argument as to why willfulness was the appropriate standard. The language added by the American Defense Act in 2011 said that an accused infringer's failure to offer or introduce advice of counsel as a defense to a willfulness claim may not be used to prove that the infringer, and this is the key phrase, quote, willfully infringed the patent. But this phrase, willful, only makes sense if it ties back to the enhanced damages provision in 284, because direct infringement, as you may know, under 271A is a strict liability offense. So where does the mental state come in? It comes in for enhanced damages. Now I thought also that the brief filed by the members of Congress was quite interesting. I'm perhaps, I think, a little more skeptical. We didn't get into this in our brief because it was just due to the timing of the brief, the amicus members of Congress came after we had filed our brief. But in terms of I'm a little skeptical of it as a post hoc legislative history, given that Seagate was never mentioned in contemporaneous legislative statements, and as Mr. Wall, Petitioner's Counsel, had noted, that language regarding the standard for enhanced damage was initially introduced in a predecessor bill, but ultimately dropped from what became the American Invents Act. And I think the third point that wasn't mentioned by any side was that the American Invents Act in 2011 actually predates another decision that wasn't mentioned a lot, but I think is also important, Bard versus W.L. Board, decided by the Federal Circuit in 2012, which held that the objective prong is a threshold test to be resolved by the judge, and if that threshold test cannot be met by the patentee, that terminates the willfulness inquiry. And so I think sort of arguing that AIA through 298 not only adopted the willfulness standard, but also adopted Seagate is somewhat problematic for those reasons. With respect, the second main point is that Seagate got some things right, but also some things that we thought it got wrong. I think it got right the fact that the standard prior to Seagate had been set too low. The underwater devices case by the Federal Circuit in 1983 essentially said that all you have to do is prove a negligence-like standard for getting eligibility for enhanced damages. We think the Federal Circuit also got it right that at least recklessness is required for enhanced damages, but we think that the Federal Circuit made a mistake in requiring this rigid two-part objective-subjective test, and that the Barr versus Gord case further compounded this error by bifurcating the willfulness inquiry into these separate objective and subjective steps, one of which would be resolved by the judge, the objective prong, and the subjective prong, which would be resolved by the finder of fact, which often is the jury. And our other main concern was that by terminating this willfulness inquiry at the objective or threshold step, it would often result in the fact finder not being able to consider very important evidence regarding copying, which has already been mentioned by the panelists. And I had done a previous empirical study that found that copying was the most significant factor favoring a finding of willfulness. But you can see the problem if there's an objective, some reasonable but unsuccessful litigation defense, and thus the objective prong cannot be met, the fact finder never gets to consider that subjective evidence of copying. And so the third part, and this is where we favor, I guess, the petitioner, is that in light of this recklessness threshold for enhanced damages, we argue that the Supreme Court should adopt a totality of the circumstances approach that would permit the fact finder to consider both objective and subjective factors together at the same time to determine whether the infringer had acted at least recklessly with respect to the patentee's rights. And we argue that part of this is consistent with the standard for punitive damages in tort law generally, and there are a number of cases. The one we didn't include in our brief, but I'll flag for interest, Smith versus Wade, 1983, dealing with torts under Section 1983, rejected the fact that specific intent was required for punitive damages, said that reckless conduct alone was sufficient. So that was our overall position.
Right. So the court acknowledged the quality of the briefing and thought the issue is well presented, clearly presented. At argument, Mr. Phillips and the justices were looking for something different than the Federal Circuit's test, but really looking for a standard and trying to bargain with arguing counsel, which is always a difficult position to be in. But Mr. Phillips said, basically, Your Honors, you have to choose. You're either on the side of the pirates or you're going to catch a few pirates who are these willful copiers, and in doing so, you will be arming the trolls with a very strong enhanced damages standard. So you have to choose, are you on the side of the trolls or the pirates? And the justices were not necessarily persuaded, but from your perspective, after listening to the argument, what are the issues remaining in the minds of the different interlocutors that they either did or didn't get the answer to based on the argument? And maybe why don't I just sweep down the table. So, Don, your biggest takeaways from the exchanges?
Well, it's hard to wargame how they're going to end up, but it's clear that Justice Breyer was concerned about trolls. He was very concerned about that. He made a couple of comments near the end indicating that is there some other solution. The transcript is already out, amazingly. It was out an hour after I got back to the office. And I went through it kind of hurriedly. Toward the end, he joined sort of quietly the chorus of, is there some middle ground? But basically, he seemed to be mostly concerned about trolls. Chief Justice Roberts seemed mostly focused on discretion, on letting the district courts have discretion. And if he followed through on that, then he obviously would be favoring the petitioners. And if Justice Breyer followed through on his view, he obviously would be favoring the respondents. Justice Sotomayor, at the very beginning, talked about needing some guide. We need a guide. And at that point, it sounded like she was favoring something like Seagate, but then she expressly said in so many words she didn't like Seagate. She said that. Justice Kagan, sitting at the opposite end of the bench, seemed to be coincident in her views with Justice Sotomayor. She seemed to be concerned not only about the little company that Justice Breyer was talking about, but as Justice Sotomayor said, you focused on the little company. What about the big companies? What about the patent owners? She expressly talked about that, her concern that you had to look at both sides, suggesting at least, and you never know what's going to happen after the oral argument, you never know whether Justice Breyer is in conference going to make an impassioned speech and convince anybody to come over to his side. But in any event, so those are 4 justices. Justice Ginsburg, it's hard to tell where she is. First of all, it's difficult really, she is infirm and she sits stooped over on the bench, and it's difficult for me to hear her precisely, and that's why I was anxious to read the transcript. I don't have a good sense of where she is. Justice Kennedy, at one point, he asked a question that suggested to me that he seemed to be favorable to the respondents, but then Justice Kagan followed up with a question and characterized what she thought Justice Kennedy was looking for, which cast some cloud on that interpretation. So the only one Justice Alito, it was hard for me to reach a conclusion as to where he is. I don't really know where he is. He wasn't in one or the other of the camps that I've been describing. And of course the big enigma is Justice Thomas, whose questions did not suggest anything, but he did ask.
Yet who always writes patent cases.
Though, yeah, he does. He often authors patent opinions. But for those of you who were in the courtroom, you'll notice that he did ask questions because he was talking to Justice Breyer.
Yeah.
They had an active conversation going, and I don't know what that was about. I don't know whether they were talking about questions that Justice Thomas was concerned about and passing them on to Justice Breyer, who then might have asked. I just don't know. So I mean, it's difficult to count. But so I mentioned the Chief Justice, and then the Justice Sotomayor and Justice Kagan is 3, and then so that's 3, and it's hard to tell. I mean, there may be lurking in there votes for both sides. I wouldn't try to fathom a guess, and who knows what happens in the conference.
Right. Jim, any?
Well, I think that was a really good summary. I mean, I think the one thing that Alito was concerned about was Section 298, and how do you get into the subjective state of mind of an infringer without invading the attorney-client relationship.
That's true. He did.
And I think that Mr. Wall gave him a pretty good response on that with respect to Section 298, which is that opinions of counsel, if a defendant gets one, they can use it if they want, or they don't have to use it and it can't be held against them. And that's what Section 298 says. It was interesting in our case, Don, I know you weren't trial counsel when we had our trial and intervention, but MGA's trial counsel told us that they wouldn't give us opinions that they had gotten from counsel, that they weren't going to rely on those, and we said, okay, well, you don't have to. Section 298, it's up to you. And we can't obviously use that in front of the jury. But then when it came to trial, they put on their witness list somebody who was going to testify about the opinions during trial. And the judge she was outraged. She actually let us take this guy's deposition during trial. And then after we took his deposition, they pulled him and sent him back to California. So some additional litigation misconduct in our case that I think justified treble damages. But the one thing I was going to say, I think Don did a really nice job of summarizing the justices' positions. It was interesting to me when this kind of goes to what Justice Breyer's hang-up was on, well, aren't we going to really hurt small companies if we change the standard? And also Carter Phillips, when he said, hey, it's trolls versus pirates, who are you going to help? We really need to squash the trolls because there are so few pirates. And I have a different perspective on that, and it's not because I represent intervention necessarily. It's because I'm a patent attorney in Silicon Valley, in the San Francisco Bay Area, which is one of the most important industry there is startup companies, where you have inventors who come up with an invention and it is the lifeblood of their company. That's the only advantage they have against a big internet company or a big chip company, is their intellectual property. And if they're in a situation where they know that the big company can rip them off with impunity, that it will discourage innovation. That will discourage investment in innovation. And that's the main industry we see where I practice law in Silicon Valley, which is venture capitalists investing in great new ideas, which, the patent system helps protect that and foster it. But if we have a willful infringement standard where a big company can knowingly rip that off and say, well, we're going to come up with an objectively reasonable defense at some point in the future, hire smart lawyers to do that, then you're in a situation where you're discouraging, these small inventors from innovating.
Right. So, Michael, on the argument, how did you read the bench?
So I thought it was very interesting that almost every one of the justices mentioned something in favor of willfulness being the standard. That wouldn't have been necessarily my expectation coming in, having read the briefs, but it did seem that almost all the justices were on board with the willfulness standard. The exceptions, in my mind, being Justice Ginsburg, who didn't say anything really on the subject, and Chief Justice Roberts, who seemed fairly committed to the idea of discretion rather than a willfulness standard. I will point out, actually, that I think we got a rare glimpse into Justice Thomas's perspective as Justice Breyer was starting to say he didn't know where, he was starting to talk about Section 298 and whether or not Seagate came into it, and at the beginning of his sentence sounded as if he was going to say there's no basis for it. That's not what he said, but it sounded like he might have been going there, and Justice Thomas actually leaned over and pointed to a brief and mentioned Seagate under his breath, or at least it certainly seemed that way from the exchange to me. It almost certainly won't be picked up on the record, but I thought it was notable. It did seem that the justices were really struggling with the idea of the subjective infringer who was going to get off the hook. The idea of the person who intended to infringe a patent but got off the hook because of the objective standard. I mean, near the end of the argument, especially Justices Kennedy and Kagan really put a fine point on that and ask some very difficult questions on that point to the respondent. So I think it seems like general agreement over willfulness, but what does that mean, and how do we capture these bad actors that we really want to capture?
Chris?
I think that's a great summary. If Justice Breyer's comments are indicative of how he feels, I think he's probably pretty safely in the respondent's camp. But it does seem to me that I think that's right. There's at least probably at least a plurality, perhaps a majority, that seem to be accepting willfulness or some sort of bad faith mental state is necessary for enhanced damages. But the question, I think, sort of seems to be, if they don't like Seagate, and they did seem to be, I think Mr. Feldman accurately noted, be hung up on this idea that a subjective bad faith infringer could get off simply because they had an objectively reasonable litigation defense, then what do we do about Seagate? If we don't like it, do we supplement it with some just straight subjective test? Do we scrap it entirely? And that seemed to be the area that I'm going to be most interested in seeing what the court does. If it's not Seagate, what are we going to replace it with? And that's, I think, a very, very important question. And I thought the other thing, and I think that was mentioned, that the trolls versus pirates, I thought that was actually, in terms of rhetoric and framing, I thought Mr. Phillips really did a nice job of sort of trying to capture that, and it was very effective. You know, it's a heavily policy-oriented argument, but sort of saying, who do you really worry about, the trolls, the pirates, and that should sort of suggest which way you should go on this case. I think my response to that would be partly twofold. One is that in this particular case, I understand that both of the patentees were in fact operating companies. Stryker clearly is a large medical device manufacturer. Halo is a much smaller company, but from what I understand from its website, actually does make and sell products. So I don't think you could probably characterize either of these folks as their main business being patent litigation. The other sort of concern I have is about the frame of trolling generally, right? Sometimes trolling has been used as a term for entities who do not make and sell products. But if everybody who doesn't do those things counts as a patent troll, it's a very broad classification. It includes universities that have large patent portfolios but don't directly practice it. It includes startup companies who are engaged in innovation but haven't yet brought a product to market. And it might also include failed operating companies, a company that did in fact attempt to make a good faith effort to bring their product to market but simply failed and are now trying to, through litigation, recover some of their research and design costs. So I'm a little leery of sort of using this troll label to capture all of those entities, but I think some of them actually are engaging in innovation and doing some very good things that we don't want to discourage.
So this is all good. I agree with everyone. The one thing I'll say that I found most interesting was I think Justice Breyer at some point suggested that Congress should make a specific statute for software patents.
He did.
He did.
It's a little inartfully done, but he's suggesting that. And I've never seen that publicly from a justice before. So that's the thing I found most intriguing about that.
That was a dog whistle for me, since I've written a lot about how and when you can and cannot tailor intellectual property rights. So I'm going to be quoting that piece of the.
Yeah.
One last observation, and I think we have time for about 2 or 3 questions from the audience if folks want to do that. But one interesting thing to me that maybe we can talk about at the reception is, Justice Breyer, who often slips into administrative law mode, kept talking about the way in which this standard allows the Federal Circuit not only to be uniform, but to use its expertise. So the circuit has had a pretty poor batting average at the court, but suddenly it's the expert decision maker that's entitled to a certain amount of deference. And whether he persuaded anyone else that maybe we should just let them sort the calves from the goats, or the sheep from the goats on these willfulness cases. It was interesting, at least, that he seemed to be willing to give the Federal Circuit a little bit of credit, given its track record and his general views about their rigid tests in the past. That was a nod. Do we have any members of the audience who want to ask a question? Yeah.
I thought one of the really interesting comments that Justice Alito asked is one of the questions: what does reckless disregard of other people's rights really mean in guidelines? It's a really fundamental question. I think this argument didn't answer for me briefly, didn't answer for me, right? And how that's different from tort law. So there's one question sort of the panel I'm thinking about writing on is: why is it talismanic that you know the specific patent? Tort law, for example, just in generalized disregard of other people's rights, often helpful and damages, right? Maybe sort of going off what Michael said, a failing to do a search that would be reasonable for other people's patents, right? I've done it as a prosecutor, not consultant earlier. A failure to do a search, maybe that can trigger enhanced damages if your freedom to operate, setup is so overly deficient, right, that you fail to find a patent that you should have found, right, so we're hoping to understand. So that question to me really started to get answered, and I'm wondering what you kind of thinks about it.
Jump ball.
Yeah, no, I think that's a great question. I would say I probably don't view it as simply failure to search would qualify as reckless, unless there is some other indication that they were aware of the patent and there was some indication that they were likely to be infringing. So I would, because my concern would be sort of a duty to search gets dangerously close back to the sort of least sort of widely rejected, underwater devices negligence type standard. But it's a good question about, sort of exactly where does that threshold, sort of where do we jump the bar from, gross negligence to reckless to sort of specific or knowing infringement. And I think it's one that we'll probably have to see some case law develop on.
I think you're right in that the patent law differs from the tort law, and this goes back to the Federal Circuit thing. I mean, the Federal Circuit's been criticized for making patent-specific rules in an area that has other things. So, attorney's fees has patent-specific rules. The Supreme Court knocked it out. But maybe there are instances where they need patent-specific rules, and maybe the Supreme Court should defer to them. So it goes back to all those kind of questions. So I think that's a more interesting question than they give it credit for.
I would say I think I don't think there's been a definitive answer to that in the Federal Circuit and the district courts or in the Supreme Court, at least that I've seen. But it seems to me that the trajectory of the decisions would indicate that a failure to search at least would not be recklessness. I mean, we start with underwater devices where first knowing about the patent is sort of the baseline, and it seemed, at least at argument today, both among the justices and the arguing counsel, that no one wanted to go back to a standard even that low. And since that, if we're talking about that as the floor, then knowledge of the patent is the floor.
We have a question.
I mean, I think I'm sort of piggybacking on that. The balancing of when the potential infringer knew about the patent. I mean, Mr. Feldman mentioned that there are companies who would commit to a product without even looking at what's out there. In fact, instructing their innovators to not really look at it. And then going back and saying, well, we didn't know of it when we committed to the product, and say, that's why we cannot be held for willful infringement. I mean, it's a balancing act of whether an innovator is willing to spend that upfront money to look at, two new patents and figure out whether they're infringing or not, or whether they would have freedom to operate or not, versus going back and having the risk of being potentially willful infringement. I don't know.
Yeah, I think that's precisely the problem, right? That Treble, at least as articulated in our brief, the problem is that innovating companies are incentivized not to look at patents because they're worried about treble damages. Personally, I think that in an ideal world, you would be encouraging innovating companies to go out and look at other patents and make sure that the space is clear and see what's there and see what can be built off of what exists already. But as a practical matter, it seems to me that you can't incentivize companies to do that if merely doing that is going to tag you for willfulness and treble damages.
And one of the reasons that, one of the things that led to Seagate was that concern,
Yeah.
that companies were not searching for fear of being tagged with willfulness. And I would just follow up that another issue is, even if you don't know the patent, when you first go to the market, if you later learn of the patent, there could be a potential problem with continuing activity leading to willfulness. So that's a separate problem.
No, I think that's a great point, right? Because we sometimes treat infringement as occurring on a set date and ending, but right, it's often a continuing course of conduct in which you may know certain things at certain times that would make it more or less likely to be reckless or intentional at various
And
times.
Justice Breyer made a point.
Yeah.
So I think on that point, we're going to bring this to a close. I want to thank the folks on the internet who joined us and the folks in the room. We have food for you. We can't feed the internet yet. It's coming. So, but with that, I want to, if everyone could thank the panelists for joining us.